Number 19, matter of Abdur-Rashid versus the New York City Police Department. Counsel?
Good afternoon, Your Honor.
Good afternoon.
My name is Omar Mohammadi. I'm representing the appellant Talib Abdur-Rashid and Samir Hashmi. May I please the court?
Mr. Counsel, would you care to reserve
Omar Mohammadi.
Mr. Mohammadi, would you care to reserve any rebuttal time?
Yes, 3 minutes, please. Thank you.
You're welcome.
The NYPD, by using Glomar theory, we cannot confirm and deny the existence of document, assert blanket objection. In violation of the false policy, plain language, and legislative intent, the NYPD could not support the Glomar theory under any New York State law precedent. The NYPD argues that Glomar is only a form response.
Well, what isn't it obvious from the legislation, since the legislature has carved out these exceptions, that the role of the court is to ensure that those exceptions indeed have some meaning? So if the answer reveals the information that is indeed excluded, don't they have an argument for us to say, yes, we have to allow them to be able not to tell you whether they have it or not, so that they protect the very exclusion that the legislature has already adopted in the statute?
But, Your Honor, you know that there are exemptions under FOIL, and those exemptions, they have to be narrowly construed. And in your case, Friedman, the latest case in Friedman 2017, you specifically mentioned that a certain exemption for the requester of the court to understand and evaluate the validity of the exemption is important to the principle of particularized exemption. We cannot confirm.
Yes, but I think the point that they're trying to make is if their answer actually reveals the information that the legislature allows to be exempted, that they need a way to respond to protect that very information that the legislature has already identified can be exempted from FOIL.
But under FOIL, the exemptions require that the agency will have to explain what is the exemption with particularity. Okay. Why do we want these documents not to be produced? We cannot confirm and deny existence of documents, Your Honors, are blanket exemptions. Yeah, they're not particularized exemptions.
Doesn't it create a situation where it would be impossible for a law enforcement agency to conduct a confidential investigation if those being investigated could always ask, are we being investigated?
But isn't that the spirit of FOIL, that you have an open government?
Let's leave the spirit of FOIL aside and focus on that question. Would it be possible to conduct a confidential investigation if those being investigated can always ask, are we being investigated?
Your Honors, how many times the NYPD was able to respond in response to FOIL requests with exemption, where they said, those are confidential information, and Friedman itself talks about confidential information.
Friedman was a public prosecution, so there was really no reason to keep files from, reason to assert a Glomar response. I mean, it wasn't whether or not Friedman was under investigation, but the more particularized your inquiry is, the more difficult it is to respond in the ordinary way to a FOIL request, right?
But this
is
not...
Judge Fahey was saying. I mean, if somebody comes in and says, am I under investigation, I want all your files, or somebody comes in and says, I want all the payment records from NYPD to this individual who they believe may be a confidential informant. The fact that you have to go in and say, I have these records, but they're exempt under one of the exemptions, really proves to the person seeking the information that it exists and violates the spirit of those exemptions.
it does not, Your Honor, it does not violate the spirit of those exemptions.
Kind of violates the actual fact
FOIL,
of the exemption.
FOIL was established and then open government policy was not established under secrecy. And what the NYPD is trying to do is trying to foster secrecy, which is actually detrimental to the public.
Counsel, this case involves, as you say, the NYPD in a particular program, but the rule we're going to make from this case, whether or not we adopt this GLOMAR exemption or GLOMAR response, will apply to everything. So not to the NYPD, but to any FOIL request. So while you may point to allegations of what seem to me amount to bad faith on the part of the NYPD, isn't that something that's factored into the GLOMAR procedure?
GLOMAR procedure are federal procedures that were tethered under the Freedom of Information Act that relate to specific exemptions under Exemption 1, which is executive order and classification of documents, and Exemption 3, which is act of Congress. The NYPD does not have any of that to be able to use it, and they tether it to FOIA and say, here we have a right to say we cannot confirm and deny the existence of documents.
I think what Judge Garcia and the other judges are trying to get you to do is sort of broaden your thinking about this beyond the specifics of this set of facts. Because whatever we decide in terms of this set of facts is going to have a broader implication. And I don't think that the response is really answering Judge Garcia's question.
Okay, the response should be, I think this issue should go to the legislature, not this court, to decide on this issue, because the legislature has already promulgated harm under which the exemptions were issued. And exemptions are not, we cannot confirm, deny, which is really a blanket and carte blanche exemption that this court has already said it's not applicable under FOIL.
Let me try the same thing a different way. Is there any hypothetical situation you can imagine in which a GLOMAR response would be appropriate, or none, under FOIL?
We know under this case there's no way this can be applied, but in a hypothetical situation, I think it will be applied case-by-case basis. And I'm not here to argue. I'm going to argue on behalf of our clients in this specific situation. I think case-by-case situation is very important in FOIL for any request or what they offer, what they're requesting. In this situation, we know that the requester is asking information on themselves, not a third-party request, on themselves. So
Are you saying there should be a different rule on this between first-party and third-party requests?
I mean, we for public policy issue or for privacy issues, yes, but not under GLOMAR. I don't think GLOMAR should be applied, even if it's a third-party request. I think the court will have to go with the legislator, finding which is the harm of revealing information, and will have to interpret the legislator intent rather than making decision instead of a legislator. It's very specific. The exemptions are really narrowly construed. And the NYPD has already asked this court not to apply the rigid per se exemption, which is meaning what? Meaning its exemption has to be construed. And the NYPD said we should not be doing that.
So just to clarify, you're acknowledging that there may be situations, leave out whether it's this situation or not, in which simply answering the question of whether documents do or don't exist may reveal exempted information. What you're saying is that it's up to the legislature to correct that? Is that
yes,
your argument?
because we believe, Your Honor, is the harm. This is question of harm that is going to cause for revealing information. But harm has already been defined by the legislator. The NYPD is trying to create a different standard of harm by saying we cannot confirm and deny the existence of documents. This has never been used by the NYPD, by any city or state agency, to say that we cannot confirm and deny the existence of documents based on harm that has already been legislated by in the statute. It has already, the intent is clearly you need to answer. You need to say, we have documents, we cannot produce them to you.
Thank you, counsel.
Yeah.
Counsel?
May it please the court, Devin Slack on behalf of the respondents.
Counselor, See, I waited to get your name out there. I thought that was good.
Appreciate
it. But the problem I have here is that the affidavit that you're required to put in requires by statute, a particularized and specific justification. How is a Glomar response ever a particularized and specific justification for not releasing certain material?
I think it's going to differ depending on the request, but
Well,
it has to be.
that's petitioner's argument that we should take these cases one at a time. It's
Right,
not relevant here, but it
which
may
is a
be
new
relevant.
argument that I've heard. Then.
Go ahead.
It has to be particularized and specific to the information that would be revealed by disclosing the existence or non-existence of responsive records. Just like within.
So a response that says I can't affirm or deny, you would say that's particularized and specific?
No. So like let's take
So
it in
if
this
it's
case.
not, let me just follow through on that thought then. Then is legislative action required to change that standard before we can change that standard?
No, because, I mean, what's interesting about this case is when petitioners argue that any agency has to do X, they haven't pointed to anything in the statute that says that. If you look at 89.3A, what agencies can do, one of the options is to, quote, deny a request. If that goes to an administrative appeal, then they have to fully explain their reasons in writing. Nowhere anywhere in FOIL has the legislature said that agencies have to answer the question of whether or not there are responses.
Counsel, that's very fine, but the reality is that historically, this court has said, and it's very clear from the legislation, that this is a disclosure legislation. The point of this is transparency, to turn over documents. The point of it is not to say, I don't know if we have it, or I won't tell you if we have it. But I have a different question for you, or I have a question for you. It's a different provision of FOIL, Section 89, 5A1, and also 1-A. Granted, this provision deals with trade secrets, but nevertheless, it contains the following language. Where the request itself contains information which, if disclosed, would defeat the purpose for which the exception is sought, such information shall also be accepted from disclosure. Doesn't that language suggest, at a minimum, that the legislature, when it wants to do exactly what you're requesting us to say you can do, it puts that kind of language in the statute? That is to say, if the legislature really wanted the kind of response that you're advocating for to be considered adequate under the statute, it could have said so in the other sections that we are talking about, these narrow carve-outs.
Right. I mean, I'm less familiar with this procedure, but as the way I understand its purpose is not to answer the question whether or not records do or not exist, but to give the person who has a vested interest in the trade secret an opportunity to object. So I do think it's designed for a different purpose.
Well, it may, but that's not, I don't disagree with you that it may, because obviously it's in a different section. My point is not that one. My point is that if the purpose is to protect the underlying information secrecy along with information that leads to that underlying secret information or information that is seeking to be maintained confidential, that the legislature full well knows how to include such language. And not having done so in this statute should signal to us that, as your adversary says, this is a question for the legislature. And when it wants to give you, and you can obviously lobby for it, when it wants to give you the opportunity to provide the kind of response that you think is necessary, which may very well be, that my question is not about the underlying merits of that. I'm just talking about whether or not this is a legislative or a judicial role.
I think that actually probably cuts in the other direction, because when the legislature did carve out the general obligations of agencies, it didn't specify that agencies have to answer the question of whether or not responsive.
What it said was you either have to grant it, you have to deny it, or you have to say you can't find it.
Correct.
Basically, right?
Correct.
None of those says you can say, I don't want to tell you whether I have it or not.
I think it's much more open-ended. Denying a request and tethering it to exemption is exactly what happened here. And then if it goes to the next level, 89.4A says
But my point
you have
is
to fully
there's no
explain it.
exception that says, because I can't tell you whether or not I have it.
But it doesn't say, tell me whether or not you have it. It says you can deny a request and explain your reasons in writing.
This is
That
the
is a
way it's
broad
always been interpreted. So let me ask you this. It's a point made by one of the courts below. This seems to have functioned very well for law enforcement with the way we've interpreted this in the past. What has changed? Why is this necessary now?
Yeah, I mean, I think
I mean,
there's...
Glomar's been in place for a while also at the federal level.
It has. It's only been recognized by some circuits recently, like 2009, so I don't know how much to draw from the timing. I think there's a lot of
Perhaps
things.
more reason for us to step very slowly and leave this to the legislature.
Well,
yeah?
I think one reason why the world has changed is, I mean, simply the internet and social media. The harms of disclosure are much different than they once were in 1970s when FOIA was first described.
But that doesn't answer the question as to who should make this determination. I mean, the federal statute has certainly carved out these exceptions under 552C, right? And I haven't found any cases dealing with the criminal investigation exception or exemption that relies on GLOMAR, not on that statute.
Right.
And so
I can give you
it seems to me
two.
that the you can give me two, good.
They're cited in our briefs. I don't have the sites, but,
And they don't have to do with
Platsky
privacy.
versus NSA and Vasquez. The first one's out of the Second Circuit, the other one's out of D.C. But there are a number of cases that are under Exemption 7E because the statute that you're referencing, 552C, isn't GLOMAR. It's something on top of GLOMAR that was enacted in the 80s. And that works differently. It's not actually an exemption, it's an exclusion. So what it allows agencies to do in that context, in addition to GLOMAR, is when they think even citing an exemption can cause a harm, like identifying which one, then they can treat it as if it does not fall under FOIA at all.
It seems like the vast majority of cases falling within the types that you're now seeking to use GLOMAR for are really 552C situations.
I don't know empirically, but certainly courts have been clear that GLOMAR is available under any exemption and has applied under the law enforcement exemption, under which FOIA's
The other
FOIA's
thing
is
is
modeled.
that under 552C, it's very specific and very narrow, and that's not usually
Right.
the kind of thing that courts do. That's usually the kind of thing that legislatures.
Absolutely. Just to be clear, we don't believe that there is something equivalent to 552C under FOIA because that carves it out of FOIA entirely. It allows an agency to say those records do not exist. They don't have to do a public affidavit under 552C. What they do is in every case, the DOJ submits an in-camera affidavit. It is a process that is less public than GLOMAR. What GLOMAR traces from is the general structure of FOIA, which is the general obligation of disclosure, which is true. FOIA and FOIL are both open records, but there are also open record requirements that are coupled with specified exemptions that the legislature made clear that they are the kind of information that, if disclosed, are expected to cause harm. That same structure is exactly...
And each one's a policy choice. So let me ask you this. It's in part what your adversary has argued, both today and in the briefing, and it is mentioned in the decisions below. I don't understand, and you can help me here, please, how GLOMAR works unless it is a blanket statement that you can make, that it applies in a way across an entire classification of documents.
Right.
Because otherwise, if you use it so selectively, isn't that really telling the person who requested, I guess they have it?
Right,
Because
right.
otherwise, they either say they do
No,
have
no,
it or
no.
they don't have it.
I totally agree. I think there's actually just kind of conflating what is a specific and particularized explanation as to the category of information, which FOIA requires and FOIL requires. And then is the inquiry about the information that would be disclosed on the by responding to a request interpreted from the face of the request is a more abstract kind of inquiry. You just look at the face of the request, you determine what information would be disclosed if I respond, whether there are or are not responsive records. And then from there, you're just basically an ordinary FOIL litigation trying to tether that.
Isn't the consequence of your position that if I ask whether the police department has records about me, you must give a GLOMAR response?
Definitely should.
No, must, because if there's a slight chink, then your rationale falls apart.
I think for it to be effective, it needs to be consistent. I don't know if it needs to be completely
But if I
consistent.
ask and you give it to me, isn't it
No,
obvious?
absolutely, absolutely.
Once you go down this road, you've got to invoke that GLOMAR response every single time.
No, absolutely. I mean, to be effective, it needs to be consistent. I don't know if every single exception would
now
tell you
let's
that
circle back
much.
to my earlier point. isn't that a decision for the legislature to make if what you're looking for is an additional carve-out from FOIL?
I mean, just to be clear, we're not claiming that we're expanding any of the exemptions one iota. It's just a question of whether that information falls within the law enforcement and public safety exemptions. And I've never heard an argument that identifying the specific identities of who is or is not subject to surveillance or investigation, recent or ongoing, isn't implicated by those exemptions.
I know your red light has gone on, but if the chief will permit me one question. With respect to the actual affidavit, let's say we agree with you that Glomar, indeed, we should adopt it with respect to FOIL. How does the affidavit that was submitted, or anything else you submitted, satisfy the requirements?
I think it starts with Chief Galati's affidavits explain that identifying the specific identities of surveillance and investigation allows them to evade detection. Even knowing when people are not subjects of investigation is valuable information to people. I think you can stop there pretty much, but the affidavits go on in quite a lot of detail as to how additional harms can flow from that.
It's all phrased in sort of conditional language, though. It may let them do this. It might. It's not. It's less than an affirmative statement that this will happen in his experience.
I would disagree about that. There are particular aspects where he does, but I think he does make clear that the disclosing the identities of surveillance and investigation is something that would likely cause harm. And it just needs to be would likely, not a certainty under this court's jurisprudence.
Counsel, are these common requests that the NYPD get in these FOIL requests? Am I under investigation? Or covert investigation?
To my knowledge, and actually Chief Galati's affidavit mentions this, one of the things that has changed in recent years is that people are more often asking about events that are not known already. But to my knowledge, that it is not, the Glomar response has not been used more than to this kind of requests on 2 occasions. But we do know that there was a coordinated campaign to solicit this kind of information, but to my knowledge, that there weren't actually responses to that.
Thank you, Counsel.
Thank you.
Counsel?
Your Honors, I'd just like to mention that the NYPD has said that under the federal rule, and Glomar was applied to, for instance, he mentioned Pulaski case. Pulaski case, even though it was a law enforcement exemption, it really relates back to the national defense under exemption 1 and 3, because all of those were CIA, NSA, and FBI. So everything was relating back to exemption 1 and 3, and even at the Gutledge, where a requester was the FBI, but since the requester documents were document to national security, Glomar was asserted. And this goes also to a classification of documents that the NYPD does not have. In addition, even under federal rule, for instance, in Shapiro case, 19 District Court 2016, the court here states specifically, although the Glomar doctrine may constitute a gloss on FOIA text, it does not lead to a result fundamentally at odds with the statute. So even if you apply Glomar, if it's at odds with the statute, it's not going to be granted. And that's exactly what the NYPD is doing. At the federal level, it says specifically that. And also...
Well, if we were to recognize something akin to what Glomar is in the federal system with more stringent requirements, require an in-camera review, would that address your concerns?
Actually, yes. Actually, that's what you said in Friedman. That we need that the court will have an ability to review the validity of the objection. That's what Judge Martin said specifically. The NYPD, by claiming Glomar, which is a blanket carte blanche objection, which you already said is not applicable under FOIL, right, is not even allowing this court to have in-camera review. It's not even.
Explain to me, how would you have in-camera review without them answering the question as to whether the documents exist?
I mean, in-camera review allows the court, even if the party is not allowed to see it, the court will be able to see it. But responding to it is not harm in itself.
What I'm saying is if you're asking the judge to review the documents to see whether, doesn't that assume that there are documents, and doesn't that then answer the question that Glomar is intended
And
not
that's
to
the
answer?
reason why the NYPD should not claim, we cannot confirm or deny the existence of document that has nothing in the statute that says that. By the way, the three answers.
How would you work? You said that'd be okay if there was in-camera review, but I just don't see how the two can work together.
Because Glomar does not allow camera review, therefore Glomar should not apply to the statute under New York State Freedom of Information Law, period.
Let me ask you a very specific to this case question, which is, what is it that you feel is insufficient in Chief Galati's affidavit? So in other words, if we were to disagree with you and adopt some version of a Glomar exception, and then we would have to turn to looking at the Chief's affidavit, what's insufficient about it?
I think I'd like to make one comment about the Galati affidavit. And this goes back to Judge Malton's decision, right? When he says that before, the NYPD was able to protect information without having to assert Glomar. The Galati affidavit listed many plots that were able to stop, right? Even though some of those were, we objected to, still, it shows the NYPD was able to do it without asserting Glomar, and Aldef is case in point. Glomar was not asserted in Aldef when it was filed a request where...
That was for broad information, isn't that?
But it doesn't matter. A principle, it's a legislator theory. Glomar, it's not inherent in FOIL. So it's for the legislator to say, we need to really install this for us to be able to use it. This court cannot do that. Harm has already, like his guy name, I will say again and again, harm has been already established and has been already studied by the legislator. Therefore, exemptions were issued. Exemptions do not allow, we cannot confirm and deny existence of documents, which is, we mentioned under Section 89, that there are three ways of answering. We cannot deny, or we can neither deny or confirm. Is not denying.
Thank you, counsel.
Thank you.